Justice done dirt cheap. It's August 25, 2012. I'm going to give you an update. I was in court on August 15, 2012 for a morning session hearing, or scheduled that I was supposed to plead to 2 criminal charges and an answer to an undertaking. Now, because of the amount of stress I've been under, I've experienced ill health, and because of that, I've appointed a power of attorney to speak on my behalf if I'm not well enough to speak. At the hearing, I presented the court with an affidavit which contained a copy of the power of attorney appointment document, as well as a visit confirmation letter signed by a doctor, and a copy of a prescription for medication I was prescribed for anxiety and depression. I informed the court. My power of attorney got up and began to speak for me, and the court refused to acknowledge my power of attorney. It is my right to appoint a power of attorney, and under these conditions, the court should not be able to refuse hearing my power of attorney speak for me. They did anyway. They refused to acknowledge her position and refused to hear anything she had to say. So I was forced to stand up and speak on my own behalf, which I did. Now, what was amazing is that there's a lot of confusion that day. The judge didn't realize that I was supposed to plead to 2 criminal charges and respond regarding an undertaking. Now, what I informed the court of is I demand a hearing pursuant to the Criminal Code of Canada, which allows for a hearing where, and it actually states it clearly in the Criminal Code of Canada, that one is not supposed to be forced to sign an undertaking until one of these hearings is held. And at this hearing, the people requesting an undertaking have to plead their case to the judge, present whatever evidence they can, and I, as a defendant, would have an opportunity to respond, present my evidence, and then a judge would decide whether an undertaking would be warranted. Now, an undertaking is a severe limitation. It's a severe limitation on one's freedom. Now, we have the Constitution of Canada, the Charter of Rights and Freedoms, which protects our freedoms and does not allow a violation of our rights unless in accordance with due process of law. In this case, the judge refused to schedule a hearing regarding the undertaking. If that hearing was scheduled, the parties requesting the undertaking would have, like I said, had an opportunity to present their evidence to convince the judge that a violation of my freedoms is warranted in the circumstances. The judge refused without any reasons, and then went ahead to schedule a hearing at the same date as the trial. Now, what's unreasonable about this is the date of the trial is almost 8 months from now, and I'm having my freedoms violated in the meantime. Now, this has been a series of events and a long chain of events where the police actually arrested me without the powers to arrest according to the Criminal Code of Canada. So I was unlawfully and illegally arrested regarding this undertaking. I was forced to sign an undertaking under protest and duress or go to jail. So I signed it to stay out of jail and had a hearing before a judge at the earliest possible opportunity, where the judge refused to drop the undertaking and refused to change the conditions of the undertaking. Since then, there's been other undertakings because of things that have happened, and now I have many layers of conditions of undertaking, which is basically it's like a sword hanging over your head that's ready to drop at any second. And it's wrong that I be forced to endure one of these undertakings when I have a right to a hearing where the people requesting it would have to prove their case to a judge before I'd sign it. All the way along, the police have failed to follow proper procedure. The Crown prosecutors and the judges have all failed to follow proper procedure, and they're refusing to correct this mistake. So that's what happened August 15, 2012 in the morning. Thanks for listening. It's Justice Done Dirt Cheap in Fredericton, New Brunswick, Canada.